Good morning. Welcome to the First District Court of Appeals. We have a number of consolidated cases to be argued this morning. I see that counsel is present, so I'll just quickly run through the cases that we have on the docket today. The first set of cases are three cases that have been consolidated. C-25-0103, Williams versus Durrani. C-25-0104, Whalen versus Durrani. And C-25-0481, Fletcher versus Durrani. And I will ask counsel to please stand and introduce yourself and say the party that you represent, please.
Good morning, Your Honor. Taylor Lovejoy on behalf of appellants Dr. Durrani and Cass, arguing in the first three consolidated cases today.
Thank you.
Alan Statman prepared to proceed, and Moran is also here, but I'll be doing it.
Great, thank you. And then second, we have two cases that have been consolidated as well, C-25-0171, Mounts versus Durrani, and C-25-0174, Neal versus Durrani. Will counsel please stand and state your name and the party that you represent in those two cases?
Philip Williams on behalf of Dr. Durrani and Cass. So I believe Weisbecker was consolidated with those two.
Oh, I apologize. Yes, you're right. I do see that. That's C-25-0169, Weisbecker versus Durrani. Thank you.
That will still be me.
Alan Statman on behalf of the appellee, I'll be doing three, and Mr. Moran. We also filed a motion that I'll address that argument. Thank you.
All right, thank you. Okay, beginning with the first three cases, Williams, Whalen, and Fletcher versus Durrani. Ms. Lovejoy, you may come forward. Would you like to reserve time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
All right. You may begin when you're ready.
Good morning. Taylor Lovejoy along with co-counsel Philip Williamson on behalf of appellants Dr. Durrani and Cass. May it please the court. In the briefing presented before the court today, there are 6 issues for the court to consider regarding Mr. McClure and 7 issues regarding Mr. Whalen and Mr. Williams. For purposes of today's argument, I'd like to focus on one issue in particular, which is joint trials and consolidation. Before turning to today's argument, I do want to draw the court's attention to the lack of set-off in these cases as well. Pursuant to Fenner, at a minimum, this court must remand for the trial court to determine the proper set-off amount that appellants are entitled to.
We have no objection on the set-off.
Thank you.
So the starting point for determining when consolidation is proper is to look at the plain language of Rule 42. Rule 42 requires that a court must identify a common question of law or fact before proceeding to consolidating cases. Here, the trial court never identified a common question of law or fact. As Judge Reese admitted himself in the lower Reese mandamus, he outsourced the determination for consolidation to plaintiffs, and in the later Denzler action, plaintiffs admitted that their reasoning for consolidation was to put pressure on appellants to settle. And then here, on the first day of trial, Judge Reese rubber-stamped that decision to consolidate based on whether or not he could have the jurors keep the issues separate, and the main issue being that the experts here were largely the same. Now, judicial convenience and regular litigation patterns of trying these cases together or shared experts are not questions of law or fact, much less are they common. So the question then becomes, what does Rule 42's common question of law or fact actually mean? So a common question of law or fact is a common contention that's truth or falsity resolves an issue for all cases at once. And this principle is well articulated by the United States Supreme Court in Walmart versus Dukes. To put it another way, a common question of law or fact is proven with the same evidence or generalized proof, whereas an individual question requires evidence that varies from plaintiff to plaintiff. For these reasons, the generalized question of did Dr. Durrani perform an unnecessary surgery is not a common one, because here, to truly answer that whether that claim stands, the question becomes, did Dr. Durrani perform an unnecessary surgery on Mr. McClure? did Dr. Durrani perform an unnecessary surgery on Mr. Williams? And did Dr. Durrani perform an unnecessary surgery on Mr. Whalen? Each requires separate and individualized evidence to answer that question. Now here, the trial court articulated on the first day of trial that consolidation was proper because of common experts. But common experts are a product of common counsel. They're not a common question of law or fact. And common experts does not resolve any central issue of truth or falsity for these plaintiffs. And what's more, the only truly common testimony among these plaintiffs was, what is the spine?
So what would you say would be a proper situation for a joinder of actions?
Yes, Your Honor. Yeah, appellants are not arguing here today that there are not any instances.
I understand, but
where-
what would be an example?
So one example could be if you could imagine a pharmacist who prepares a batch of cancer medication for the week, and in compounding that single batch accidentally doubles the dosage. So then every person that picks up their cancer medication for that week would be exposed to the same error. So the question there would be, was the batch improperly compounded? And the answer to that question, once answered, would require the same evidence for every patient, and it would resolve the issue for all patients. Another example could be a physician who's routinely using a treatment that's categorically been discredited by the medical community, so leeches for headaches. If that same treatment is applied to multiple patients, then the common question would be resolved for all of them at the same time.
So you're not suggesting then that all medical claims are excluded from Civil Rule 42?
No, Your Honor. While we do think the language of the rule limits the instances when medical malpractice claims can be consolidated, we're not arguing that all medical malpractice claims are barred from consolidation, just that these cases here today should be, specifically because the plaintiffs are so different and don't seem to even align with this court's prior decisions with Jones and its progeny.
So, if I'm understanding you correctly, you're saying that consolidation is proper if it's one single act of negligence that might affect a bunch of different people, or alternatively, multiple acts of negligence but doing the same act which has already been found to be negligent.
Yes, Your Honor. I definitely to the first. Regarding the second, what we're arguing here today is that there has to be that common contention where the truth or falsity of that contention resolves the issue for all plaintiffs.
Okay, thank you.
And so then turning to the plaintiffs here today, a common question cannot exist because these were three entirely different plaintiffs with different surgeries, different outcomes, and different diagnoses. As a baseline, none of these surgeries occurred at the same vertebral joint, which is what we've seen often in cases like Jones and Ravenscraft. Here, Mr.
Does that matter?
It does matter.
Why? Why does that matter, and where would we look to substantiate the difference?
It does matter, Your Honor, because if we're not, beyond even just different vertebral joints, there's also differences in diagnoses, different surgeries. Those all require different individualized testimony from the experts. So, in this case here, the trial court relied on these common experts to say there was a common question. The only commonality in their testimony was about what is the spine. To then get into the actual root of the claims against Dr. Durrani, each expert had to testify about what do those individual surgeries require, what do these individual diagnoses mean.
Perhaps I'm not understanding, and I don't have a medical background, so that could be the case, but if there's a spinal fusion surgery being performed, wouldn't the spinal fusion surgery look the same at the L4-5 level and the L3-4 level? What is different about the level of the spine, and who would have testified to that?
Well, here, the L4, L5, every level, we're also looking not just at the lumbar spine, but also the cervical spine. Mr. Whalen had surgery at C5, 6, C6, 7. And in addition to that, the specific testimony would be different regarding those. I don't purport to be a medical expert myself either, but the testimony that would be necessary for one fusion in one place also is not present here. Not every plaintiff had a fusion surgery. So that would require different testimony about, for Mr. McClure, there was a fusion, but if we turn to Mr. Whalen, we're just talking about decompression, where a fusion is putting hardware into the spine, a decompression is removing from the spine. Those are different medical procedures. And I do want to point out, in addition, that this case is not Jones, where we had identical procedures and diagnoses. This isn't Courtney, where the court found the diagnoses and the procedures were virtually identical. This isn't Ravenscraft, where the conditions, the vertebral levels, and the surgeries were the same. This isn't even Boggs, which the court decided more recently and said that consolidation was appropriate because it was the same general area of the spine. In these cases, we're talking about completely different areas of the spine. Mr. McClure had 3 surgeries at L5-S1. Mr. Whalen had 2 surgeries at L3, L4, as well as C5-6, C6-7, which is moving then to the cervical area of the spine. And Mr. Williams had only 1 surgery at L3, L4, and L4, L5. None of these were at the same general area.
Well, weren't they all in the L area, the lumbar area?
No.
They all had an L area surgery.
Yes, Mr. Whalen, though, also had a C area, a cervical area surgery in addition.
So is your argument that that different procedure takes away the commonality, even though they all had an L area procedure?
Yes, Your Honor, because if we're not looking at the specifics of where that surgery is occurring, then the question really becomes, if we're not allowing the different vertebrae to matter, then this court is basically rubber stamping and saying that all back surgeries could be consolidated without any sort of common question. It does matter where the surgery is occurring.
Well, returning to your hypothetical, let's parse this out a little bit. So returning to your hypothetical where the pharmacist prepared a batch of cancer medication, let's say one of the patients who picked that up also picked up a diabetes medication. Would that mean that that patient is no longer in common?
No, Your Honor, because there's still the common question of, did they take that medication that had the double dosage? Or was really the question of, was that dosage compounded improperly?
Well, these patients all had an L-level procedure, and then one of them had a cervical level procedure. So how does the cervical level procedure impact the commonality of their lumbar procedures?
Well, really, I think I would turn to the fact that there was no common question even identified here. The trial court never said that these cases were consolidated because there were common lumbar procedures. The trial court fully based its decision for consolidation on common experts, which is why, again, this case should be remanded for separate trials, because following this court's own decision in the Reese mandamus, where it directed the trial court to consolidate as a prerequisite, that did not occur here. And this court's decision in that mandamus was in 2022. These cases happened in December 2023, well over a year after this court's decision, and the trial court is still not following this own court's admonishments and directive. And that's very important here, because then it does turn to the issue of being an end run around for Rule 403 and allowing prejudicial evidence to come in. Specifically, testimony in Mr. McClure's case is then being heard all throughout while the jurors are also considering Mr. Williams and Mr. Whalen's cases. And this is not
Well, that's always going to happen in any time you have joinder. So I think that it has to be more than just a mere existence of prejudice. And I think that's why, obviously 42 has the language of what it requires, so that it doesn't go beyond the mere. So I want to go back to Rule 42, because I'm thinking of everything you're saying, okay? I'm processing it. And I'm going to put aside common question of fact, all right? So I would like in your answer for there to be no discussion of common question of fact, right? Almost like let's presume that there isn't a common question of fact. I just want to talk about common question of law, because it seems to me that opposing counsel has in the past couched their Rule 42 strongly on the common question of law. Basically, the unnecessary surgery, the fraud itself, right? So why is it that there is not a common question of law in your opinion?
Yes, there's not a common question of law because these are individualized claims. So the question that plaintiffs are presenting as the common question of law is, did Dr. Durrani perform an unnecessary surgery? That question cannot be fully answered without identifying who it applies to. And the evidence that's required to prove whether or not it's an unnecessary surgery is individualized, looking at Mr. McClure, Mr.
But that
Whalen.
seems to me that you're saying there's not a common question of law because there's not a common question of fact. And this is what I find interesting about this, because there's an or in there. You know, so it requires for one or the other to exist in order for there to be proper joinder. All right? So if there's a common question of law, regardless of whether or not there's a common question of fact, just on the mere statutory interpretation of the language and the insertion of the or and the application of the law, the law is sufficient. So that's what I'm trying to parse out. How is there not a common question of law? Not fact, but law. Because what you're saying, because the facts are different, it changes the outcome of the law. Well, that's always going to be the case, right?
Well, the question's still not common because to resolve a common question of law, it needs to apply to everyone, not looking at the specific facts. I understand what you're saying about the different surgeries or the different
Yeah,
levels, ignoring that. The question of was there a medically unnecessary surgery here cannot commonly be answered without looking at the specific evidence for each plaintiff.
Wouldn't the fact that juries sometimes reach differing verdicts on the plaintiff's claims in these cases suggest that there's not a common question of law because there are different ways of resolving these legal claims based on the individualized proof that's presented?
No, Your Honor, we still believe that even with the different verdicts or different verdict votes, that the jurors still, you see throughout some of these cases, confusion in the number of votes, whether, or in addition, there's can be prejudice in understanding the damage award amounts that they end up awarding. And if this court's looking for somewhere specifically in the record.
Well, I think my question is that don't jurors, in these consolidated cases, don't jurors sometimes reach differing verdicts? Meaning sometimes they find only negligence and not fraud, or for one plaintiff, and then negligence and fraud for another, meaning that the verdicts don't always match.
We haven't seen that in all these cases, and that certainly wasn't the case here, where the jurors found all the claims against Dr. Durrani for all plaintiffs.
Okay, and you've far exceeded
Yes.
your time. Thank you.
Thank you.
Morning.
Good morning.
We really got to stop meeting like this. In terms of what I was just listening to, and I'll just take a few minutes to respond, and I'll start backwards. The jury interrogatories, again, are very instructive in this case because there are 380 verdicts, but they spend an inordinate amount of time numbering why they decided each one. And they have some of the similar factual reasons, and some they decided differently. So in terms of prejudice to Dr. Durrani, I think this cuts the other way, against prejudice. Now,
And counsel, is that different than some other cases where we see sometimes some split verdicts? I mean, there are Durrani cases where juries, for example, might find negligence in one case and then negligence and fraud and informed consent in another, and a certain amount of damages in one and a different amount of damages in another. Would you agree?
well, I would agree there's the same but different, and I'll tell you why. That they're the same for the purpose of what we're talking about. Because the appellants are arguing that the entire case is tainted by the consolidation And you just heard this mention of 403, I think it's really 404B, but it's tainted by all this evidence of these other things. Well, what you just asked me, that's proof it's not. And this is proof that it's not. And the fact that they lay out the negligence and don't say, because it says, state the reasons, that he did this to other people, they're not making that generalized statement that they are worried about in terms of prejudice, which is they can't separate one case from the other because globbed together, they just find in favor of the plaintiffs every time. So I think your example is good evidence that that's not happening. Interrogatory number 2 is good evidence that's not happening as well. Whether they decided 1, 2, or 3 cases in favor of the plaintiff, you can see exactly what they're thinking and doing. If we didn't have these interrogatories, then I think it could be a much more open issue, but it's not. And then on the question, you all have helped prove the common issues of law. We are here today on 6 cases that, with one exception that we'll talk about in the next oral argument, all have similar issues of law. And I said last week, another example of similar issues of law is the fact that the jury instructions are virtually identical for every case.
Well, under that standard, then why couldn't any 2 people suing for the same thing not consolidate their case? I mean, what would be the limit?
Well,
Like, let's take 2 clients suing a lawyer for malpractice. Both people are going to file the same legal claim, malpractice. So, and the jury instructions are going to be the same. They're both going to match the OJI jury instructions for malpractice. They're both going to be against the same lawyer, same
Well-
claim. Would there be a limit on consolidating those 2 cases for trial?
Well, let's talk about the first reason this doesn't really come up very often, which goes right to the heart of your question. It isn't every day that you have the same law firms representing a very large group, okay? So your example may be perfectly legitimate to consolidate those 2 cases under common issues of law. It just doesn't routinely happen, if it's happened at all, because you've got law firm A and law firm B. They're not communicating that they have a similar case against lawyer Mr. Smith that happened in the same time constraints with the same kinds of issues. It's the fact it doesn't exist doesn't prohibit it from existing. Nothing happens till it happens. But the reason you're not
So your
seeing it,
position is that so long as the claim is called the same thing, that is sufficient to create a common question of law under Rule
well,
42?
I think that there are some things that get taken into consideration by courts in the entire hierarchy, which relate to issues of judicial economy, same witnesses. For instance, you're not going to have potentially the same expert witnesses when you have 2 different lawyers who don't even know about each other. So there isn't going to be commonality of witnesses. In our situation, if we started trying these individually right now, maybe we could get 40 tried a year, and we would be here for another 10 years. We've already done 13
What would you
years.
say is the common issue of law in this case, in these cases?
Absolutely.
No, what would you say it is?
consolidated them, and we have the same jury
I don't think you were
instruction.
able to hear me. What would you say is the common issue of law in these cases?
The common issue of law are the elements of each jury instruction. It is a medical malpractice claim. It is negligence. It has proximate cause. It has damages. It has descriptions of the legal elements for whether the doctor performed an alternative method that was acceptable under the standard of care, or was this a negligent method? There are 40 pages of common law, not common law, sent to the jury in each of these cases. And
typically, we are only changing the names. We are only changing the names in the jury instruction. That's how common the law is, all the way through 40 pages.
Is it in common? I think maybe we're all zeroing in on the word common. So does common, in the context of Rule 42, mean that the instruction that's being given to the jury is the same? Or does it mean that the jury's answer is the same? The jury's resolution has to be the same? Which one is it?
Well, I don't think the jury's resolution has to be the same, because Rule 42 wasn't put in place to deal with what the jury ultimate answer is. It's put in place to decide how the case will progress. We're not dealing with where it ends up. We're dealing with how does it progress. And I think common doesn't mean...
So it's common question, not common answer.
Right. But I also think that common in the sense of this rule isn't exact, it's similar. Similar issues of law or fact. Not exactly the same issues of law or fact. And that gets us to the factual similarities as well, which is, and I play a doctor on TV, okay? I'm not a real doctor, but I have now 500 clients and 127 trials. So I have some familiarity. And what the court should understand in terms of the common facts is that every fusion includes a decompression. You cannot solve a patient's radiculopathy, meaning radiating pain, without a decompression. So the question then is, okay, was the decompression destabilizing enough that we need to add the fusion to it? And remember, the hardware just holds things stable.
What about the point that there's a difference in these procedures if they occur at the L3, L4 level versus L4, L5? Is that?
That's absolutely wrong. If you do an A lift, you can do an A lift at any one of those lumbar junctions. You do a D lift, you can do it at any one of those.
And so the experts, I mean, my understanding of these cases is that the experts at some point are going to be explaining that a decompression looks like this. This is how you do it, this is what it is, and they're going to be describing that procedure, whether it occurs at L3, L4, or some other part of the spine. Is that correct?
That's correct. And moving forward, since this has become such a hot topic in oral argument, I don't know where it'll turn out in your ultimate opinion. I'll ask that question and get that specifically in the record, because they're not asking it. They're not saying on cross-examination, now, doctor, this is L5S1. You couldn't do that same procedure at L4-5. Well, yes, you can. As a matter of fact, if I had a basket full of lumbar vertebrae and I threw it on the floor and I asked any one of you, any one of us, or any physician, tell me which one's an L5, which one's an L3, they couldn't do it.
And all of these three patients had procedures in their lumbar spine, right?
L5S1, L3-4, L4, L5, all lower lumbar, not upper lumbar. We're not even talking about like L1-2, where it's just under the thoracic spine. We're all the way in the low back. It's the most common area, L3 through S1, that lumbar surgeries are done. Every fusion includes a decompression by its nature. You're removing part of the disc. You're doing a discectomy in anticipation of the fusion. You're doing a discectomy to help relieve the compression. So a good portion of it is identical in each procedure.
What about the point that at least one of them had a cervical procedure as well, and they had some different diagnoses? How does that factor in?
Whalen, they talked about doing a cervical procedure, but ultimately decided not to. It was Williams that they did the cervical procedure, but when you're in, as we talked about last week, when you're in the lower aspect of the cervical spine, a fusion or decompression is the same procedure as it is in the thoracic or lumbar spine. The only reason you don't see much of this in the thoracic spine is because of the ribs give extra bracing, and you don't have the movement in the thoracic spine. The cervical spine and lumbar spine has similar range of motion, similar twisting, turning of the head, et cetera.
And so
it's-
is your point there that the expert testimony about the procedures in the lower spine would also have applied to the cervical procedure, and that would have benefited the jury to know?
If I ask the question, are you in essence decompressing the nerve in the cervical spine as you were doing in the lumbar spine, the answer is identical. The difference is radiculopathy in the cervical spine goes down your arms, radiculopathy in the lumbar spine goes down your legs. That's a dermatome map that has been around since the 1860s when a doctor, a physiatrist, dissected a human and determined where every nerve root went. So that's static in every patient. They may vary a little tiny bit with anatomy, but we know where each nerve root innervates throughout the body. So when you're in the cervical spine, you're talking about things going down the arms, the hand, up into the bottom of the head if it's in the high cervical spine. Thoracic, it comes around the trunk. Lumbar, it radiates down the legs into the feet. Different toes if it's a different nerve root, but still the toes. Front of the legs, back of the legs, side of the legs, all similar from the same dermatome map that is used consistently since the late 1800s. I don't know how much similar anatomy can get when both sides use similar dermatome maps. The defense always puts up, well, there can be some variations. They show one that has a little bit of the nerve moving over, et cetera, but we've got the similar dermatome map, the fact that all of these people need decompressions of the nerve root to stop radiculopathy. So it just becomes now a question of common issues of fact mean exactly the same, or does it just mean similar? And it doesn't mean exactly the same, because nothing in this world is exactly the same factually. You would have no reason to have a rule that talks about common facts if it was exactly the same. And the reason their pill argument fails is if I were defending and she put that up and I wanted to make their argument, I'd say, well, you know, everybody reacts differently to pills. Some people may have thrown them up. Other people may have passed out. Someone else might be in a coma. Somebody else might not be affected at all. I mean, I can go through 100 reasons they're different.
So in essence, what you're saying is common does not have the same meaning as the word same.
Yeah, I think it,
Okay.
yeah.
It's as simple as that.
I think it means similar, common. Because if you talk about,
I don't know that common means similar. I hear you saying that common doesn't mean the same, but
Well, it
common
certainly
seems to me,
doesn't,
common seems to me a subset of the word same. In other words, common means that there's some commonality, but there's also could be some things that aren't common.
right, but I think when you say some commonality, you mean similar. Some commonality and similar, to me, would mean the same thing.
Okay.
So,
To me, they mean something different, but that's okay. It's, beauty is in the eye of the beholder.
well, and again, you have questioned us till you all blue in the face on this issue. I have answered the same, and ultimately, I think you have a variety of these cases now ripe for decision since we've gone through oral argument. And so I think that, we're in good hands, and we've kind of beaten this dead horse flat. And I don't know what else to say about it, except Ben does point out that a fusion, a decompression, or a foraminotomy, those terms are not level specific.
Right. Thank you very much.
Thank you.
I'd like to draw the court's attention back to the plain language of Rule 42. Judge Kingley, as you mentioned, it's common question, not common answer. And as this court already explained in the Reese mandamus action, it's the duty of the trial court to determine the common issues, and the trial court should not be giving deference to the plaintiff in scheduling the cases and grouping the cases. And that's exactly what we saw here. Additionally, this court went on to say that finding of commonality in each action is a prerequisite of consolidation, meaning it must happen before. It can't happen when we get to the stage of the jury interrogatories. And if this court is looking for somewhere in the record that clearly shows where there was prejudice from consolidation, it's likely not going to find a clear statement where the jurors say, this is where we were prejudiced from the consolidation. If that were the case, then the jury interrogatories need to have narratives asking those specific questions. And we would ask this court to think about general
But
human.
that's a common issue of prejudice, and we face it all the time in criminal cases. It's very hard to get a criminal case reversed on prejudice, whether it's a Strickland analysis or harmless error, whatever it is. So,
We would present that this is different, though, than just a simple passing moment of prejudice where the trial court can ask the jurors to ignore the statement that was made. These are 3 cases that are plagued the entire way by prejudice from consolidation. Human psychology, there's implicit bias that the jurors are going to incur
again,
because
present in every case. And I understand you're making your best argument. I'm just trying to get to the right answer without analyzing things that are going to be present in every case that there's joinder.
Well, and if this court wants to perform whether or not the error was prejudicial or harmful, it could look to Rule 61. And we would say in Rule 61, it's asking, is the error inconsistent with substantial justice? And the facts here would indicate that it is inconsistent with substantial justice. Here, Judge Reese refused to do what Civil Rule 42 required of him and what this court has already directed him to do.
And I find that argument interesting. I actually have been thinking about that particular argument on the remand, right? So let's say that we were to agree with you that that saying, because he did it on common, or the judge did it on common experts. And let's say we were to agree with your argument in whole, right? We would still have to then deal with the sort of the harmless error part of it, right? So how would you address that? And I think that we're getting back to the to the prejudice argument.
Yeah,
Judge Zayas, do you mind if I piggyback on your question?
Oh, go ahead.
In a criminal case, the prosecution has the burden to show that an error was harmless. Can you address the standard in a civil case when you are answering Judge Zayas'
Are you asking about who has the burden?
Yeah, to
Yeah,
show
it's
that
gonna
an
be the
error is
appellant.
harmless.
But, yeah.
well, to begin with.
Or not harmless, sorry. And it would be showing that it was not harmless.
So to begin with Judge Zayas' question, appellants present that the harmful error analysis is baked into Rule 42 already. But if this court does not agree with that, it could look to Rule 61.
And just for clarity from where I'm coming from, I mean, 42 is when the decision is being made on the joinder by the trial court, right? 61, and I wrote separately on this,
Yes.
is when you are now appealing and saying, okay, it was in fact harmful, and there was in fact error in doing it, and then 61 applies as it applies, whether we're talking about other things besides joinder. 61 just applies, okay? So on that backdrop, let's talk about the 61. And I like that you're referring to 61.
Well, so if we look at the language of Rule 61, it states that an error is grounds for granting a new trial when the error is inconsistent with substantial justice. We have to then look to the record of, is the error here of consolidation inconsistent with substantial justice? The record does show that it was, based on Judge Reese and the trial court failing to follow Civil Rule 42 and find a true common question, failing to follow.
But isn't
this-
that the error itself?
I'm sorry.
Isn't that the error itself? Basically, the substantial justice you're saying is failure to follow 42. Isn't that the error itself, not the prejudice?
That is the error, but it's also the prejudice because it's allowing a trial court to let 3 cases proceed that are then impacting evidentiary rule 403 and 404 and operating as runarounds for those rules, which those are also bases for finding that it was inconsistent with substantial justice. It's allowing these 3 cases to be heard simultaneously and asking the jurors to keep them completely separate while hearing overlapping testimonies. And I would note also in these cases, even though we talk about common experts, not every expert testified for every plaintiff in this case. So specifically, Dr. Bloomfield only testified for Mr. Williams and Mr. Whalen, yet while the jurors are also considering Mr. McClure's case at the same time while hearing all of this testimony that only applies to those 2 plaintiffs in particular.
Counsel, you far exceeded your time.
Yes.
Thank you
Thank
very
you.
much. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The next set of cases are Wiesbecker, Mounts, and Neal versus Durrani, C-250169, C-250171, and C-250174. Counsel, thank you for arguing many cases this morning. Mr. Williamson, you may come forward. Would you like to reserve time for rebuttal?
4 minutes, Your Honor.
All right.
We have a fair amount of ground to cover here, so you'll forgive me if I try to move quickly. May it please the Court, Philip Williamson on behalf of appellants. There are 3 issues here, and I think the Court has to address all 3 in this set of cases. The first is the application of the statute of repose to Ms. Neal's claims. And the Court has to address it because the remedy there actually is a judgment in Dr. Durrani's favor. It's not something that would be mooted out by granting a new trial. If the Court then applies the statute of repose, the remedy as to the other 2 plaintiffs tried alongside Ms. Neal is to grant a new trial as to those 2 plaintiffs. The second issue is regardless of how the Court handles the statute of repose, it should vacate the judgments below because you have a juror in this case who sits on the jury, ends up being the deciding vote, who says, I think 3 cases is a pretty good indication that, Dr. Durrani is liable. And the third issue is what we'll call the sort of the consolidation simpliciter, which we spent some time on this morning, but if time allows, I think I'd like to touch on at the tail end today. But I want to start with the statute of repose, partly because the Court has to address it, and frankly, partly because Ms. Neal didn't. You will notice there is no mention, no response, no discussion at all of the statute of repose in Ms. Neal's brief. Like it's an assignment of error that just doesn't appear there. So I'm anxious to see what you will hear at argument. But the application is pretty straightforward. Ms. Neal's claims survive only if Elliott versus Durrani is good law. And the General Assembly has told us as directly as it
Well,
can.
is that
no, it's
really
not.
the issue, or is the issue more one of retroactivity of the statutory amendment?
So there are 2 ways to approach it, Your Honor. One is what I said, which is simply that Elliott is not good law, and that is what the General Assembly
I
has
understand your
indicated.
argument that the legislature essentially overruled Elliott.
Not essentially. It said use that word exactly.
Well, does the legislature have the power to do that? I mean, isn't that a separation of powers issue?
So you have the dissent in Wilson inviting the General Assembly to do exactly what it did, which is if the General Assembly thinks we got it wrong, tell us. And the General Assembly acted as quickly as you can
I
expect.
mean,
the
from where I
legislature
sit, legislatures enact and amend laws, and courts write and overrule decisions. What's wrong with that view?
Well, because the decision in Elliott is over. What did the General Assembly intend, and what did the General Assembly do with the statute of repose and the saving statute? That's the fight, is just what do these words mean? The General Assembly is certainly sort of within its power to say, Court, you got our work wrong. You did not construe the statute consistent with what we wrote. And the General Assembly can do that with retroactive effect. It's perfectly permissible to pass a retroactive statute as long as the General Assembly communicates that it's meant to be retroactive, and you have that with the overrules language in the statute
Is that
itself.
I want to make sure I understand your argument on express intent to make the statute retroactive. Is the entirety of your evidence that the legislature intended to make this retroactive that comment about overruling Elliott, or do you have some other argument?
I think that is the heart of it, though I would caution, it's not a comment. It is a part of the statute. Look, that.
In the bill, it's section.
It is in the bill. That's
Yes.
correct. You'll see in our brief, like, overrules is one of the phrases that the Ohio Supreme Court has recognized communicates retroactive effect. So we cite the Peerless Electric case, where the court, in talking about overruling a decision, says two, I think, important things. The first is, it means that the prior decision, the overruled decision, was never the law. That's the Ohio Supreme Court's take on the word overrule. Second, it says that overruling has retroactive effect.
Well, doesn't the legislature know, I just want to I want to make sure I understand all the dimensions of this. So doesn't the legislature know how to say the statute is retroactive? I mean, there's case law from the Ohio Supreme Court that says that if the legislature is going to make a statute retroactive, in essence, it should just say that.
So the Ohio Supreme Court does not say that, and it's because in most retroactivity cases, you don't actually have the General Assembly saying this statute is retroactive. You will get things like the statute applies to all claims currently pending. We had this conversation when we were talking about amendments to the rules of evidence. It will talk about applying to all cases, on or prior to a particular date. But actually, the phrase, this statute is retroactive, is not one that you're going to find in many, if any, of the retroactivity cases. What you have here is the general, so what the Ohio Supreme Court has sort of endorsed is there are a menu of things the General Assembly can say as long as whatever it says communicates retroactivity. And here, the General Assembly chose a phrase that the Ohio Supreme Court itself said communicates retroactivity. And so what you would have, I think, is a rather odd situation where, well, when the Ohio Supreme Court says a decision is overruled, that's obviously retroactive. And when the General Assembly uses the exact same word to describe an Ohio Supreme Court decision, we don't know what they mean, and that couldn't mean retroactive.
I have a question on procedural posture on the judgment on the pleadings, okay? So the judgment of pleadings was initially filed, right? And this was, I think, in 2017. And then later, there was, I think, an amended complaint or a new case that was filed.
There was a severance of the Baker complaint, yes, Your Honor.
Okay. And a new judgment on the pleadings was not filed after that.
That's correct, Your Honor.
Okay. So how is it that that's even in front of us or was ever in front of the trial court and is not held moot?
Well, it's certainly not moot.
And why is that?
Because you have, and I think my colleagues on the other side will agree with me, you have the same case. It is still a motion directed to this case. If the court is going to treat sort of the post-severance Neal case
When you
as
say you
a
have the same
separate-
case, was it the same complaint?
You're right. No, I think there was some rewriting done to
Because it-
basically break up a 300
Yeah.
plaintiff.
Unless I misunderstand, I believe, isn't there case law that says when the complaint is amended, then that previously filed motion, and the motion on the pleadings, is now going to be moot unless it's refiled, because now you have a new complaint.
Your Honor, I think it's difficult to apply a rule like that here, where the only reason for the amendment is that you had to sever a group of cases that were improperly consolidated in the first place.
Okay.
We shouldn't have had 300 plaintiffs brought on a single complaint with a single filing fee. This was the subject of a few years' worth of litigation. And so it's an issue that should have been addressed by the trial court as to Ms. Neal.
Well, how would the trial court know that? How would the trial court know that it needed to address the 12C motion on Ms. Neal's case in specific if there was not a 12C motion filed once her individual action was filed?
Well, Your Honor, I'll again point to something that I think my colleagues will point to is you have the same judge. Like, it's the judge ordering severance that then ends up with Ms. Neal's case. And you would put plaintiffs in a sort of odd position to say, look, the motion only counts if you remind the court that he needs to decide it, which I will tell you as a litigator is something I am rather loath to do. I think all of you have had the experience of like waiting for a trial judge to decide an issue and not wanting to provoke the court.
Did you
by
ever,
saying-
did you request the court at any point to decide it in all the years that it was in front of the court?
We did not, Your Honor. Again, for sort of the litigator's sort of instinct, I'm not going to tell the court to hurry up and do its job. That's something I leave to you
Was
all.
the original 12C motion directed at all 392 consolidated cases or just certain ones?
No, the motion issue in this case was directed specifically at Ms. Neal. So-
Only Ms. Neal's case?
Yes, there are a number of 12C motions directed to some of the Baker plaintiffs, but the motion that we're dealing with here was directed specifically to Ms. Neal.
All right, I want to make sure that I understand. There is a consolidated action filed with 392 plaintiffs, one complaint.
Correct, Your Honor.
Then there is a 12C motion filed that says dismiss Ms. Neal as a plaintiff out of this case under the statute of repose.
Correct, Your Honor.
Then the court orders the 392 plaintiffs to file individual actions, unconsolidated, and Ms. Neal does that. And then the 12C motion is not refiled. Am I understanding the procedure essentially correctly?
Essentially correct, Your Honor, yes.
All right, thank you.
So I want to understand your argument. So Judge Zayas brought up the case law saying that if an amended complaint is filed, then, and there's no motion to dismiss on the amended complaint, then it's considered waived or foreclosed or whatever. So are you saying that there is an exception to, if that is indeed the rule, you're saying that this would be an exception to that because it's the same judge and because it was the court that ordered the separation?
And what you have here is essentially a transfer of each of the separate Baker plaintiffs to a new case number.
So more of a transfer than an amendment, is what you're saying?
Correct, Your Honor. I think in circumstances like this, and in fact, you have in fact a transfer here. I think you shouldn't have the court simply skipping over resolving that motion. I have a couple of things on consolidation that I think may address some of the questions the court had in the previous argument, if you want to hear it, or I can save that for rebuttal.
Your time is up. Thank you.
As I said earlier, we filed a motion, and we asked for leave to supplement our brief because there was an editing error that left this assignment of error off. And it's obvious because each of our responses to the assignments of error in their brief are misnumbered because of the missing number one. So we've asked to be able, we've just asked for 24 hours so we can,
When did you file that?
what's that?
When did you file that?
This morning before the oral
Okay.
argument commenced, because my understanding of the First District law in general is that if I'm going to make a motion, oral argument can't be closed to have the motion filed prior to the close of oral
I just
argument.
asked because I hadn't seen it.
No, I just discovered this. I made the mistake of leaving this to be my last argument to prepare for because I knew they would be emphasizing it. And it wasn't until late Sunday night that I realized that when they put the brief together, they took it out because they were mirroring the other two.
Gotcha.
And so that's why I've only asked for 24 hours, because the work is done. I just have to get the people to fix it. And unfortunately, the person that is most in charge of this works a weird set of hours starting at 5:30 in the morning because she has a family and wants to be home early afternoon. So I've asked for that. And if you'll indulge me, I do have some comments directly to what we've just heard. And when you use the word transfer, well, again, we're getting back to these definitions. It is an amended complaint. It is a new case number.
Do
And-
you agree with my explanation of the procedure, more or less, that there was a consolidated complaint, there was the 12C motion, then there was the amended complaint, and then no renewed 12C motion? Is that your understanding of
There
what
was
happened?
no renewed 12C. And the severance of all those complaints caused all the complaints to then be different, because you had to take out all of the common allegations to all the plaintiffs, make them individualize, file the complaint. So they're not the same. It's a new case number, and procedurally, it requires a new motion. Any time you get a 12C motion filed, if the result is an amended complaint and you don't like the amended complaint, you have to file a new motion. That's just the way it works. There isn't an exception for the plaintiff improperly consolidated too many people, so we're going to divide it up and everything that happened under that one case number. And the fact of the matter is, I fought for one case number because we ended up with millions of dollars in costs because we had to file everything 400 times. And then the costs got astronomical. And the argument was always, you can't do it that way because of this court. It won't make sense to the appellate court if they aren't individually numbered by case number with all the motions that apply, all the rulings that apply, all the facts, circumstances, et cetera, in their separate silos. So we had to pay 400 filing fees, and we had to pay millions of dollars, or we've run up millions of dollars in costs, some of which have been paid out of previous settlements. So I don't think you can just say it was just a simple transfer. And
When the 392 plaintiffs were unconsolidated and the amended complaints were filed, they each got their own case number, right?
absolutely, that was one of the big issues, whether it was the same judge or not. The clerks, this became an administrative nightmare where we actually had a hearing with the clerk of court's people, and one of the judges now was the attorney for the clerk of courts.
So in that
Talking.
regard, was it as if the cases each started over because they each got a new case number?
Well, they were considered filed as of the consolidated date, but each case then got their separate issues, discovery, motion practice, et cetera, trial dates, everything.
I want you to answer the question only if you know.
Yeah,
Both
sure.
of us can go find the answer. But if I go look at the trial court docket for each of these cases, like Ms. Neal's, for example, do you know if I'm going to see her amended complaint as the first thing, or am I going to see back into the 392-person consolidated action? Do you know the answer to that?
I am virtually certain that you will see the first filing under that case number. Am I 100% certain? No. But the whole purpose was anything that was in that consolidated case wasn't going to be considered other than the filing date for, statute issues.
And that case had its own case number.
That had its own
And then
case
it ended when it was
When it-
unconsolidated.
Right, when they and this is, as you'll see, we have, and these gentlemen are on the, and lady are on the other side, we have the same issue in this Dr. Saul case.
I have questions for you about the retroactivity question. So we had some conversation about the legislature's intent in including language that it wanted to overrule Elliott. What do you think that language means?
Well, in order to answer that, I need to explain how I see it. I actually argued the Elliott case, and we won it on a motion for reconsideration, actually. What I think has happened here and is not being discussed, as probably I wouldn't if I were in their shoes, is that Elliott actually gave people a substantive right. Their argument prior to the Elliott decision was, you're outside the statute of repose, your case doesn't exist. So Elliott gave those people that would have been found to be outside the statute of repose a substantive right, the right to pursue their claim. Now, if you're the legislature, how do you not take away that substantive right, but protect what I'll call the good doctors from what I'll call the Dr. Durrani rule that in essence Elliott created, which is if you're running and hiding from the law, you're not going to get to run from people that have claims. So by setting it up that it's substantive because the right was granted, but you want to argue that it is administrative in its enforcement, they can't apply it retroactively. So they get to apply it to all those cases, moving past the ones that created substantive rights while Elliott was in place. And I agree with the comments I was hearing during the appellant's argument. I don't believe the legislature can substitute its opinion and then take away a substantive right created by a court, which is what happened here. And they talk
I
about
understand
it.
your argument as to the second prong, the substantive right versus a remedial right. I understand what you're arguing. But what about at step one, the legislature's express intent?
Well,
What does that language about overruling Elliott mean? Is that the express intent to make the statute retroactive, or is it something else?
I think that when you talk about express intent for retroactivity, since this is a constitutional issue, both under Ohio law and the United States Supreme Court, you better be more specific about your intent than just using a single word that we intend to overrule. That doesn't seem to make any sense when you can just say, and it applies to pending cases and retroactivity. It's retroactive, just like Judge Reese found that it wasn't to be retroactively applied because a substantive right was being affected. And I don't think, they can tell you about, well, these legislatures that did this are all attorneys. I don't think you know that any better than I know that. And
Well, wouldn't that cut the other way? I mean, if the drafters of this bill are in fact attorneys, then they would understand that part of the test for retroactivity is express intent to make the statute retroactive. And the
Well,
easiest way to do that is to say
the words.
statute is retroactive.
Right. That's why who knows what each vocation of the legislator that participated in this was. What I think the overall intent was, protect the medical community with an absolute 4-year bar, but don't let Dr. Durrani, who fled the United States without a passport, on bond from criminal indictment for 75 counts, get away with nullifying claims against him. It makes perfectly good sense when you think about it that way. Because I don't think they would have gotten a unanimous vote in support of this if they thought that they were protecting Dr. Durrani from legal civil claims. There's just no way they could have sided with him in that fashion. And that's why they don't use the words retroactive application, and we fall back on constitutional issues. It's really, to me, it's focused in that way. And I think the intended result has occurred if you don't apply it retroactively, which is the bad guy doesn't get away with running, but we protect all the good doctors, and we're not going to make you count days he's on vacation and everything else. that you can count under the statute of limitations versus the statute of repose. So I get back to the idea that the legal system is obviously a system of
And
justice.
is this the way, by saying that the intent is to overrule Elliott, is that the way that the legislature would have best expressed a prospective application? Exactly what you're talking about. Like, we don't want to leave this rule dangling for doctors in the future who are doing their best, but we also don't want to interfere in pending Durrani cases. Is this what they would have said?
We all probably would have half the work if legislatures said things that they meant in clear, simple, I'm sitting at the bar talking to another guy language. It just doesn't happen that way. They don't make it as simple as, you want to prove a tort, here are the 4 elements. They don't do that. They don't start from the fact that words have meaning, and they throw words out there that are consistent or inconsistent with what they're trying to prove, and that's why courts sit around scratching their head and having to interpret statutes that the legislature puts in place. So now we've got this first impression issue on Elliott, and you're left to interpret what the legislature meant. And I think there's only one way to do substantial justice in the case, which is you don't side with the guy that fled without a passport out of the country. You look at it and say, what is the logical answer? Protect the good doctors, but you know what? Dr. Durrani made his own bed. And that is what leaving Elliott applied prospectively, not making their decision about Elliott retroactive.
So that I understand, are you suggesting that if there's ambiguity in the legislative intent that we should consider public policy?
Yeah, I think that that's clear, and you should also then fall back on what the court's decision was in terms of looking at public policy, and why did they do what they did on that motion for reconsideration. They thought about the fact that we can't encourage people to flee to beat the statute of repose. It really comes down to that, and I think that when you talk about justice and you talk about public policy, you still get back to fundamental concepts of logic. And logically, I think my argument makes far more sense than theirs, which is how do we deal with this Durrani thing, yet protect? And when you look, if you look at the legislature as a whole, they are hugely lobbied by the medical community, the hospital community, the medical insurance community, and they lean right, protect the doctors. It just all kind of lines up that I'm not surprised that they want to protect what they would call the good doctors versus the bad, because this is a rare exception. How many Dr. Durranis have there been in the history of medical treatment in the state of Ohio and jurisprudence in the state of Ohio dealing with somebody that did this to 500 people? So it presents a whole new set of circumstances for all of us to look at. And all I can say is there has to be a way that these people get their case in front of a jury without being negatively impacted by someone that fled back to another country.
Counsel, you're out of time.
Thank you.
Thank you.
So, Your Honor, first on the motion to, I suppose, amend the response brief, we got service to that motion at 9:34 this morning, which, if I'm not mistaken, all of us were in this room when that occurred. So I've not had a chance to see opposing counsel's argument. I mean, literally hearing it for the first time at the podium here. I think there are a few things to pull out there. The first is the sort of the interesting admission that in filing a new complaint for Ms. Neal, plaintiffs pulled out the, quote, common allegations in the complaints, which seems relevant to our consolidation conversation. Would also note, the trial court sat on that motion for judgment on the pleadings for a year before severing the cases. I believe, Judge Kinsley, you asked, sort of, what would you find if you go look at the docket? Actually, among those first entries is a transfer of the record from Baker to this action. And if record means anything, it would include the motion that had been directed at Ms. Neal's complaint. And the amended complaint sort of doesn't moot the motion here because nothing in that amended complaint even is intended to or even accidentally addresses the substance of the motion, which is this claim is time barred.
So go ahead.
Okay. I looked back at the trial court record, and the first document in there is the order to remediate non-compliant filings on order of severance and renumbering. And it says in here that plaintiff's counsel shall file an amended complaint for each new case number, et cetera, and then it says utilizing the language from the original complaint, and then it says the same thing about the answer, the language of the original answer, and then in the event a party wishes to amend their pleading, they must subsequently request leave to file an amended pleading. That language is confusing to me, because it orders an amended complaint, but then by order, but then it requires the same language as the original complaint. What effect, if any, would that have on the issue of whether this has been waived?
So, Your Honor, I think partly it sort of makes clear that we are continuing to talk about the same case and the same allegations and the same timing problem. I would actually point to sort of the back end of that order, which is if a party wishes to amend a pleading, that they have to request leave to amend it. And here, we were perfectly content to rely on our existing motion for judgment on the pleadings, and frankly, the existing answers and responses in the answer. And so I think the way to take that order is nothing about the case has really changed except the case number, and that the motion should have been addressed, and that the issue is still a live one for this court to resolve. And on the point of what you do with the motion, Judge Kinsley, you asked a number of questions related to what do we do with this overrules language. So when the General Assembly, we'll talk specifically in the context of tort reform and dealing with various aspects of the limitations periods. Prospectively, the General Assembly will say things like, we intend to abrogate the common law as announced by the Supreme Court, that we respectfully disagree with the decision of the Ohio Supreme Court, not overrules. In those cases, you apply the statute prospectively. Overrules, wherever it appears in the law, is of retroactive effect. Again, this is what the Ohio Supreme Court has told us. And so you might ask the question, you might disagree about whether the General Assembly can in fact has the power to overrule a decision of the Ohio Supreme Court. But you do know what they were trying to do when they used that language. The intent was to use overrule the same way that the court itself would have used overrule, the same way this court used overrule just last year in Fenner.
And you're asking us to read into that one word the idea that the legislature, in enacting this amendment, meant to negate the claims of pending Durrani plaintiffs that would have been barred by the 4-year absolute statute of repose.
Yes, Your Honor, and there are a couple of reasons for that. One is, look, I think it's a misnomer to focus on, well, they only used one word. So does this court all the time. So does the Ohio Supreme Court. One word or 20 words, the meaning of overrule is, as the Ohio Supreme Court itself said, retrospective in effect. The other is it's important to remember the amendment is not to the statute of repose. That would have been substantive. That is a substantive statute, confers a substantive right on defendants, not on plaintiffs. It's an amendment to the saving statute, which is a remedial statute. We know this, again, because the Ohio Supreme Court told us the saving statutes are remedial.
Right, that's the second part of the test. but,
But
right.
to answer your question, I mean, yes, Your Honor, there is always going to be sort of an impact of a retroactive application of a statute, and there's no reason to think, as opposing counsel sort of opined in his argument, we don't know what jobs the legislators did, but we know for sure that they were thinking the rule of decision here is get Dr. Durrani in particular and protect everyone else, which I think is a very
Well,
difficult.
doesn't
move for
the
this
law,
court to do.
though, tell us that we are to presume that they were thinking prospective application in the absence of express intent to go backwards?
Yeah, you will get no disagreement from me on that point, on that rule. My argument is simply that, as the Ohio Supreme Court has communicated, overrules is retroactive in a way that disagree with, that abrogate, or that sort of an unadorned passage of a statute is not. It is true, there are other phrases the General Assembly could use, but that's not the question. The question is whether this one, whether the word overrules, is itself retroactive. And again, the available case law, when the Supreme Court is describing what overruling its decisions means, is overrules is retroactive. And so to go the other way, the court would have to find somewhere in here that overrules Elliott versus Durrani means something different when the General Assembly says it than it would if the Ohio Supreme Court said it. And I don't think you have any guidance, and certainly nothing from opposing counsel, that tells you that's actually the rule. You would have to essentially make that one up on the fly. And I would suggest the court need not do that. Overrules is plenty clear enough on its own.
Counsel, you're out of time.
Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. We will take these matters under submission and issue a timely decision. Enjoy the rest of your day.
Thank you again.